Welcome to the Ask Junior Daily Judgment podcast. I'm Priya Chen, and joining me today is Arjun Khanna.
Hello, everyone. We're excited to dive into today's important judgment. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Today, we're discussing a fascinating case from the Supreme Court, Nabha Power Limited versus Punjab State Power Corporation Limited, which delves into the complex intersection of power sector policies, contractual interpretation, and the definition of what constitutes law.
This case is particularly interesting because it deals with the crucial question of when exactly a change in law occurs. Is it when a policy decision is announced or when it's formally implemented? Let's start by setting up the background of this case.
The case revolves around a power project in Punjab. In 2009, Punjab State Electricity Board issued a request for proposal (RFP) for setting up a power station near Rajpura. This was during a time when the mega power policy of 2006 was in force, which provided certain customs duty exemptions for power projects meeting specific criteria.
One key requirement under the 2006 policy was that the power plant had to be an interstate thermal power plant to qualify for these benefits. But here's where it gets interesting. On October 1st, 2009, the Press Information Bureau issued a press release announcing that the Union Cabinet had approved modifications to this policy.
The timing here is crucial. The final bidding date was October 9th, 2009, and the cutoff date for considering any change in law was October 2nd, 2009. The press release came right in the middle of this critical period.
Exactly. And let's break down what this press release actually announced. It stated that the requirement of interstate sale of power for getting mega power status would be removed, among other modifications. This was potentially significant for bidders like Nabha Power Limited.
However, the formal implementation of these changes didn't happen until December. On December 11, 2009, the government issued a notification under Section 25 of the Customs Act modifying the duty exemptions, and on December 14, 2009, the revised mega power policy was officially issued.
This created the central question of our case. Did the law change on October 1st with the press release, or in December with the formal notifications? The implications were significant for both parties.
Let's look at the appellant's argument first. Nabha Power Limited contended that they had factored in the benefits announced in the press release when submitting their bid. They argued that the cabinet decision, as announced in the press release, constituted a change in law under their contract.
The contract's definition of law was quite broad. It included all laws, including electricity laws in force in India, and any statute, ordinance, regulation, notification or code, rule, or any interpretation of any of them by an Indian governmental instrumentality and having force of law.
The appellant argued that the press release qualified as an order under this definition. However, the Supreme Court took a different view. Arjun, could you explain the court's reasoning?
The court made several important points. First, they emphasized that certainty is a hallmark of law. They cited Lord Bingham's principle that the law must be accessible and so far as possible intelligible, clear, and predictable.
They also pointed out that Section 25 of the Customs Act specifically requires exemptions to be granted through notifications published in the official gazette. This follows the principle that if something must be done in a certain manner, it must be done in that manner or not at all.
The court made an interesting observation about the nature of the press release itself. They noted that it was merely an announcement of proposals that were envisaged and would come into force in the future, subject to certain conditions being met by the states.
Those conditions included the requirement that power purchasing states would undertake certain distribution reforms. These reforms weren't even specified until December 3, 2009, when the Ministry of Power outlined 4 specific measures that states needed to implement.
The court essentially said that between October 1st and December 11-14, the existing legal regime, the 2002 Customs Notification and 2006 policy, remained in force. The press release didn't repeal or amend these existing laws.
Let me use an analogy that might help our listeners understand this better. Think of it like a city announcing plans to change traffic rules. Even if the mayor holds a press conference announcing that right turns on red will soon be allowed, drivers still need to wait until the new traffic regulation is officially implemented and signage is changed. The announcement itself doesn't change the law.
That's a great analogy, Priya. The court also emphasized the importance of following proper procedures for implementing legal changes. They cited the case of B.K. Srinivasan versus State of Karnataka, which held that laws must be properly notified and published, especially when they affect people's rights and obligations.
The court's decision has significant implications for the power sector and beyond. It clarifies that policy announcements, even at the highest levels of government, don't automatically constitute law until they're properly implemented through the prescribed legal procedures.
This brings us to an important practical lesson for businesses and legal practitioners. When bidding for projects or making business decisions, they should rely on the existing legal framework rather than anticipated changes, even if those changes have been announced by the government.
The court also distinguished this case from previous judgments where government communications were held to have the force of law. For instance, in the GMR Warora Energy Limited case, certain railway circulars were considered law because they were enforceable commands issued under specific statutory powers.
Another interesting aspect of this judgment is how it deals with the concept of promissory estoppel. The appellant tried to argue that they should be able to rely on the government's announcement, but the court pointed out that this argument actually undermined their main contention that the press release constituted law.
The court's decision ultimately means that the benefits of the customs duty exemption that came into effect in December 2009 must be passed on to the power distribution company and ultimately to consumers.
This judgment really emphasizes the importance of formal legal processes and the need for certainty in law. It's particularly relevant in today's fast-paced world where policy announcements are made frequently through various media channels.
Before we wrap up, let's summarize the key takeaways from this judgment. First, policy announcements, even at the cabinet level, don't automatically become law. Second, proper legal procedures must be followed for implementing policy changes. And third, businesses should base their decisions on existing laws rather than anticipated changes.
This case also highlights the broader principle that law must be certain and predictable, especially in commercial matters. As Lord Mansfield was quoted in the judgment, "In all mercantile transactions, the great object should be certainty."
And that brings us to the end of today's analysis. This judgment provides valuable guidance for government bodies, businesses, and legal practitioners about when and how policy changes become law.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions.
Absolutely. And don't forget to tune in tomorrow for another exciting episode. Until then, this is Priya Chen.
And Arjun Khanna, signing off. Thanks for listening to the Ask Junior Daily Judgment podcast.